Assalamu alaikum, my dear viewers, and welcome back to my YouTube channel RSK Tone YT. Today, I am here to explain a topic: United Nations Convention on International Mediation Settlement, also known as Singapore Convention. First of all, we will discuss about its introduction, and I will explain further about its total of its 16 article. Countries agree that mediation is a valuable way to resolve business dispute without going to court. Mediation helps business maintain good relationships, makes international trade easier, and reduce the burden on legal system. To support this, they have created this convention. So we move on the total of its 16 article. First of all is the Article 1 when this convention applies. This convention applies to written agreement made through mediation to settle business dispute when the business involved are in different countries or the agreement is closely connected to a country different from where the business are based. It does not apply to disputes related to family, inheritance, or employment matters. It does not cover agreements that have already been approved by a court or are enforceable as court judgments or arbitration award. Article 2 is a key definition. It's have further three subpoints. First is business location, written agreements, and mediation. Business location. If a party has multiple business location, the relevant one is the one most connected to the dispute. If there's no business location, the personal habitual residence is considered. Written agreement. Any recorded form including electronic formats that can be referred to later. Mediation. A process where a neutral third party helps businesses settle disputes but does not impose a solution. Article 3 is a general rules. Each country must enforce mediation agreement according to its laws and the rules of the convention. If a dispute arises over an issue already settled in mediation, the agreement can be used as proof. Article 4 how to enforce a mediation agreement. To enforce an agreement, a party must provide the signed settlement agreement, proof that it resulted from mediation, mediator signatures, or confirmation from a mediator institution. If the agreement is in different language, a translation must be required. Article 5 is a reason to reject enforcement. A country may refuse to enforce an agreement if one party lacked legal capacity, the agreement is invalid, unclear, or already fulfilled, the mediator seriously violated ethical rules, the agreement goes against public policy or the country's law. Article 6 is other ongoing cases. If a court or tribunal is already handling a case related to the mediation agreement, the country can basically delay enforcement and ask for security from the parties. Article 7 is basically relationship with other laws. It includes mediation validated the convention as laws mediation agreement to be used alongside other national or international law. Legal framework countries must enforce mediation agreement according to their laws and the convention. Country reservation a country may choose to exclude mediation agreement involving its government from the convention. Enforcement standard a country may refuse to enforce an agreement if one party lack legal capacity. Article 8 reservation by countries. A country may choose to not apply this convention to mediation agreement involving its governments, only applied when both parties agree. Article 9 is when the rule applies. The convention only applies to mediation agreement made after the country adopts the convention. Article 10 Official Record Keeping. The United Nations Secretary General is responsible for keeping records of the convention. Article 11-12 is signing and joining. Country could sign the convention in Singapore on August of 7, 2019 and later at the UN in New York. Regional Economic Organization, the European Union can also join. Article 13 is the countries with different legal system. A country with multiple legal system can choose which area follow this convention. Article 14 is when this convention take effect. The convention starts basically 6 months after at least three countries ratify it. For new countries joining later, it starts 6 months after they ratify it. Article 15 Changing the Convention. Any country can suggest changes. If enough countries agree, a meeting will be held to vote on the changes. Changes takes effect after three countries accept them. Article 16 is leaving the convention. A country can leave by notifying the UN in writing. The exit takes effect of 12 months later. The convention still applies to agreement made before the country leaves. The convention is written in Arabic, Chinese, English, French, Spanish, and all the versions are equally valid. Last but not least, I want to say that the Singapore Convention on Mediation marks a significant advancement in the field of international dispute resolution. It established a comprehensive legal framework for the recognition of and enforcement of international settlement agreement resulting from mediation. The convention reflects the global consensus on the importance of promoting mediation as an effective alternative to litigation and arbitration in cross-border commercial disputes. by enabling the direct enforcement of mediated settlement agreement in the courts of signatory states. The convention enhances legal certainty and confidence among international traders and investors. It reduces the need to initiate lengthy and costly court arbitral proceedings or enforce agreements already reached through mediation. In a sense, the Singapore Convention reinforces the role of mediation in the international legal landscape, promotes access to justice, and supports the peaceful settlement of disputes, thereby contributing to the stability and predictability of international commerce. I also want to include the information that the draft of this convention was prepared by UNISTROL, which full form is United Nations Commission of International Trade Law. Basically, it is a core legal body of the United Nations system that works to harmonize and modernize international trade law. It was established in 1966. I will explain about its main functions. First of all, is the draft model law and convention to help countries create consistent and fair trade laws. Second, it is promotes international trade and investment by reducing legal barriers. Third one is the works on laws related to international arbitration and mediation, e-commerce, international sale of goods, transport of goods. So this is all about I explained today about Singapore Convention. Hope you like my presentation and my video, and don't forget to subscribe my YouTube channel. If you have any question in your mind, then you feel free to ask in the comment section. Thank you.